Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for
Hello, everybody. I hope everybody's doing well. Thanks for being here for a late night show. I assume that somebody gave a little raid over to us because as much as I would love to claim all of the glory, that's not usually the numbers we start with. I hope everybody is doing well. American Courts, thank you so much. Colin, I don't know who did it, but I love you all. Thank you so much. We are on a journey this evening. We have a few from Judge Bronlick, but we're starting off in Kansas. And boy, is Kansas an interesting place, I will tell you. You're so sweet, Casey Carey. You guys, I'm so glad to see everybody here. I'm scrolling through all the comments. Ooh, cooking. Hi, Chris. How are you feeling? Worried about you? Is CRD live? Because I'm no longer hiding. Oh. Okay, so like I said, we're going to Kansas first, and I'll tell you a little something about Kansas. They are what I would call, they're on the periphery of the breadbasket of LawTube. I'll say they try. Ah, Christopher. Yay! Thank you so much. Amazing. Members only. We do it once a week around here. Well, we do this once a day around here, and then twice on Sundays. Once for Jesus and once for me. Okay. Let's just get this court show on. I don't know where he's coming from. I don't know still how all the angles get given to people on Zoom Court, how they decide to put this wherever he put it. It's not level. Were they talking? Hold on. Casey Carey, thank you so much. Streamlabs really on it tonight. Yay. You're so sweet. Ah! MB, thank you so much. We love our lurkers, and we still love you. Hold on. Did the audio just not work, or was it... He was fooling us all. He fooled us all is what happened here, folks. He fooled us all. Thank you, MB. Thank you, Casey Carey. You guys are amazing.
Good afternoon.
I'm disappearing into
Good
the
afternoon.
void, Judge. Hold on. We have a problem. Look at me. The Matrix is breaking. Stop it, Matrix. Christopher Engelby, I'm so glad to hear that. And yay, I'm glad that you're back at work. I'm glad that you are feeling better. I'm a bit concerned about my body that feels like it got the letter for Harry Potter, but I didn't, and so I don't know what's going on. Anyways, but I mean, there's a floating head up there too. Am I right? Am I right? John, you didn't miss anything. I barely hit play. Literally, I haven't even hit play.
Do we have everyone we need?
I believe so.
This is in the District Court of Brooks County, Kansas, case number 15 DM6, Tanya Ferland versus Jason Luttrell. And you are Tanya Ferland? You're Tanya Ferland? You're unmuted.
I don't think she can hear you.
I'm kitchen.
No.
Ms. Ferland?
But that is Miss Furland, Your Honor.
Okay. And you are Jason Luttrell? I can't hear you.
Unmuted too.
Still can't hear you.
We still can't hear them. They were faking us all out. What the hell's going on in Kansas? Oh dear. Come on, Tanya. Come on, Tanya. Oh. you look
Okay,
very
how about
good.
now?
That's better.
Okay, sorry about that.
That's all right. I'm still waiting for Mr. Luttrell to get his sound going.
Well, this is a really good time to remind everybody. Go ahead and like the video. Subscribe if you haven't already subscribed yet. And let us know if you ever need lessons on how to do Zoom Court. We can help with that. Also, do we remember Paisley spouting her mouth about my clear skin the other day? And look what somebody gave me. I've named her Karma.
Can you hear me now?
Yes,
Very well. Sorry about that.
it's all right.
All right. We're good now.
Okay. And Miss Krabby, we last got together on August 13th. He had made a $400 payment August 10th and was ordered to make his payment by September for a bench warrant issue. Where are we at?
So Your Honor, we had a long conversation last time about what to do if, I guess things came through the day of or the day after, mostly the day after. You had ordered a payment to be made by the 10th of each month. Jason made a payment on the 12th. I'm showing, and that may have been, yeah, I'm a little confused. One came in on the 12th, and I think that might have been, and he can maybe tell me one that he made. I also have another one that was for 210. I have another one, a receipt from today, which looks like $204.98, which would not have posted yet and has not posted yet. That looks like that's dated today. I got the notification of that at 1:30-ish. So needless to say, we issued the bench warrant back on September 11th. So there's a bench warrant out because I didn't have a payment on September 10th or by September 10th. Now I have the 2 payments. I don't know. So it's just a lot of work for my office to keep issuing bench warrants and then having to unissue the bench warrant. And, so that's where we're at. We can do this again next month, I suppose.
All right, let me just go on a momentary rant about government workers, of which I used to be one. Okay, which is where I get all this inside information. You just complained about doing your job, ma'am. Okay, that's your job that you're paid for. So I'm not sure what the fuck you're bitching about. Fucking issue the warrants and then just get rid of them. Do you want a bonus? I'm per fucking plexed at this point. Okay? Seriously, issue the fucking warrants.
Mr. Luttrell, why are you chronically 2-3 days late?
Your Honor, I'm doing the best I can. I don't have a vehicle. I'm picking up work as I can, and I'm doing the very best I can. And I'm aware of my responsibilities, and I'm pledged to make sure that they're taken care of. I'm in a tight bind right now. I'm doing the best that I can, and I'm trying to make ends meet. And so when I get work, I turn it in as soon as I get paid. And so that's the only answer I have. I'm aware of my responsibilities, and I'm trying my best to make sure they get paid.
And we've talked in the past about how much simpler this would be if you would work ahead and get 1 month ahead so that you wouldn't have these problems.
I agree, Your Honor. I absolutely agree, and I'm doing my best to do so.
Because you keep paying, but you're always 2 days late. What do you propose, Mr. Luttrell?
I'm doing the best that I can.
What do you propose, Mr. Luttrell?
I would suggest not proposing, Mr. Luttrell. That might be what got you into this problem to begin with. Thank you so much. Just doing the best you can. Mikey, appreciate that. 4-time YouTube champion, as we're calling you lately. Thank you, by the way. I appreciate that. He's 2 days late on his child support. I mean, that's I don't know, is he the one is he the one that we should be worrying about? Bill has an interesting idea. That would save, a few minutes off of somebody's day, I would imagine. Yeah, I need to probably do that, but I can't do it while I'm live. Yes, the kids are hanging out in the basement watching court. Would you be concerned if you went down into the basement and your kids were watching court? I don't know. That's sort of what my life is. Except I'm the kid watching court. And everybody else is concerned about us.
I'm doing the best that I can, Your Honor. I can't, come up with money if I don't have it. I've sold a bunch of things. I've got things listed to sell. Like I said, without transportation, it's been making work a little more difficult. So I'm picking up what I can when I can, and hopefully get the vehicle fixed. But I'm aware of my responsibilities, and I've been, paying these things as soon as I can. So that's where I'm at. I'm currently working on a job. I got more work coming in, so that's a good thing. So I'd love to get a week ahead or a month ahead, excuse me, and that way we don't have this conversation. I agree wholeheartedly. It'd be the ideal thing to do.
Now, if you could get 1 month ahead, then if you run into a day or two delay, you're still fine because you're paying ahead of time.
Sure. When I had to pay them larger setbacks when I did get picked up on those bonds and I had to come up with the $1,500, obviously, that was a large amount of money to come up with. But if I'm sitting in jail, I can't make any money. And, and then when I had to come up with that amount of money to get out, and in which it's my own fault. I realize that. But the fact of the matter is $1,500 is a lot to come up with at one time. So it has made it difficult to recover from, so, but I'm definitely doing the best that I can. I'm very much aware of my responsibilities. I'm not denying that.
Your Honor.
Yes.
He says he has no vehicle. Does he have a driver's license? A valid driver's license?
For Latrell, there's a question as to whether you have a valid driver's license.
Is this a question of the court or of someone else?
Well, the question's asked, but it's a good question. Do you have?
As far as I know, I do. I could ask that. I haven't had.
Wrong answer. I am confused because it sounds like she gotcha, buddy. The best that you can do is sometimes not good enough, sir. No, but seriously, actions speak louder than words, right? So if he really means what he says and wants to do better, then he would be hustling a little bit more, I guess, getting paid up ahead. I don't know. Tiny Piggy, what do you think? What do you think, Tiny Piggy? Legal Fiction says he's doing the best he can to get a license without being ratted out to the judge, who's laughing a bit. He's like, bitch, you're going to have to answer the question now. I mean, she is not the lawyer, but she asked a good question. I do like this judge, though. He's like a Gravol, when you take Gravol and things slow down a little bit.
It ran lately. I guess I was unaware of that. I don't have one. Last I knew, I have a CDL.
Okay, well, make sure you have a valid license if you're driving.
Well, yeah. I'll check into it because evidently someone knows something that I don't.
Okay.
Judge Bronlick would be fine with him being 2 days late. He'd be like, he's 2 days late. Get him off my docket. I don't want these numbers dragging down my fucking metrics.
Ms. Gravy.
Thank you, Your Honor. I was actually going to ask that question as well. So just to make sure that he, once the car is fixed, does have a way to get around. I guess I'm going to request this.
I was going to ask that important and crucial question, but instead I complained about doing my job. That's what she just admitted to. That's what happened. Ma'am, you had your chance to talk and you used it to complain about doing your job.
The same thing that I requested last time, that I requested the month before that and the month before that. I'm still going to keep the cash bond at 500 if the court would so allow. I would remind the court and Mr. Latrell the reason it was 1,500, and I do realize that's hard to recover from. The reason it was that amount is because the lesser amounts weren't doing anything. Because the lesser amounts, every time I had a lesser amount, he would come up with it, but he would skip 2 months before a payment would be made. And so using the bond to make the payment is great, except that still put him behind. So that's why it's at 1,500. I'm going to request that it remain at 1,500. I would request that he continue to make that payment of 400 by the 10th of the month. We're going to continue with the court's permission to issue a bench warrant on the 11th, I guess, if it's not made. So I just want Jason to be aware of that. I think he's aware of that at this point. But it's causing my staff and me having to review things more than 3 or 4 times a month to see what's going on. So we're going to request the same thing, that we come back in a month and see where we're at.
Now, you understand, Mr. Luttrell, for half the price of a bond, you could get a month ahead.
Absolutely, Your Honor. I'm very much aware of the math on it, and I'm doing the best I can. I mean, absolutely.
Well, Ms. Grabby, once again, you'll have to do the order withdrawing the bench warrant for September because he's now paid September. Mr. Luttrell, if you don't pay by the 10th, she's going to issue another bench warrant.
I realize, Your Honor, and I'm going to do my best to make sure we don't have this conversation again.
And if you would just get paid a month ahead, we could not only quit having the conversation, we could quit having these hearings.
That's my goal, Your Honor. That's my goal.
Okay? When do you want to review, Ms. Grabby?
The week of October 14th. Oh, I've got something with you that morning.
Ooh, the
I don't
clock's
know
not
what's
off.
available. Oh, hi, Jess. Is the 15th available?
Judge could do a 9:30 or a 10:30.
I could do a 9:30. Do we have one in person? Oh, no, that's in Edwards. Okay, I could do a 9:30.
Okay.
On
October
October
15th.
15th. Next hearing, Mr. Luttrell, October 15th at 9:30.
I will see you then.
Okay?
I personally thought a floating
Any
head
questions?
was a great case.
No, Your Honor.
Do you have any questions, Ms. Ferlin?
No, Your Honor. Thank you.
Okay, thank you all.
Thank you.
Bye, we said to them. She is a bit of a ball buster, I would think, Miss MB. Okay, next to Bronlick's court, who just, you know how he is. Never making anything easy. Nothing easy at all. He's definitely a ball buster.
Recalling the matter of Michael Rodriguez versus Chelsea Rodriguez.
For the record, Ms. Rodriguez has personally re-entered the courtroom, having conferred out in the hallway by phone with her attorney, Stephen Rotenberg, who's present on the Zoom this morning, along with the plaintiff father, Michael Rodriguez. Mr. Rotenberg, you've had an opportunity to discuss with, fully discuss with Ms. Rodriguez.
Hold on, I might have the case before this. I got 4 of them today. We're just gonna have to check them. Because if that's not it. But that's the one I want to watch. Let's watch this one, because this is the one I wanted to watch. I'm glad I got it. I believe this is the timeshare one, where the judge has to split up the timeshare time for them. Can you imagine? A timeshare purchase lasts longer than a marriage. I find that hilarious.
Matter Cheryl Corber versus James Corber.
For the record, this matter is before the court on the plaintiff's motion for use of the party's timeshare during the month of October 2024, as well as defendant's motion.
Yes, you heard that correctly. First of all, look at this. Moments of Justice. Thank you. Welcome. We do members only every Sunday. Also, yeah, the judge did just say that. Let's hear him say it again on the motion regarding the timeshare.
For the record, this matter is before the court on the plaintiff's motion for use of the party's timeshare during the month of October 2024, as well as defendant's motion for mediation and attorney fees. This hearing is being conducted via Zoom. Present is Attorney John Danielski, representing the plaintiff Cheryl Kerber, and Ms. Kerber is present. In addition, Attorney Michael Jones is present, representing the defendant James Kerber, and Mr. Kerber is also present. Good afternoon, everyone.
Good afternoon.
Good afternoon.
The parties have conferred with Ms. Brower from the front of the court, has provided the court with fine recommendation that exclusive use of the timeshare shall be as follows. The defendant husband, James, shall have the access to the timeshare October 12th, 2024 at check-in until Tuesday, October 15th, 2024 at 4 p.m. And plaintiff Cheryl shall have the timeshare use from October 15th at 4 p.m. until Saturday, October 19th at checkout. Parties shall notify each other by October 5, 2024 if they do not intend to utilize their exclusive use of the timeshare during those timeframes. If defendant locates plaintiff dive equipment prior to the October timeshare trip, he shall deliver the equipment to Mr. Danielski's office. And further, that the defendant's motion for mediation attorney fees be adjourned to the trial date scheduled in December 5 and 6, 2024. That is the recommendation. Mr. Danielski, is this recommendation agreeable with your client?
Yes, Your Honor.
Okay.
Yes, Your Honor.
Okay, I'm sorry, I didn't hear your response. Mr. Jones, is this recommendation agreeable with your client?
Absolutely, Judge.
Well, the court appreciates Ms. Brower's time and efforts in trying to divide up this timeshare in a manner that both parties can use the timeshare. Just for the court's future information, with respect to mediation fees incurred to date, have the parties shared that equally, Mr. Jones?
Yes.
Okay, well, that's what the court would expect on an interim basis. So yes, the court can address these financial issues of mediation fees and attorney fees more appropriately at time of trial. So the court finds the recommendation to be reasonable and appropriate, particularly since the parties can agree to share the timeshare. And obviously, presumably there's a cleaning service, correct? So when one party's done, someone will come in and it'll be ready for when Mr. Kerber leaves, the place will be cleaned up, correct? For Mrs. Kerber's use?
Absolutely, Judge.
Okay.
By
Ms. Kerber shaking her head no. We just want to make sure that it's suitable when Ms. Kerber checks in.
Sure.
Yes.
Cheryl, I'm sure he can figure out a way to make sure
I
it's
have
clean.
to pay, I have to pay to have it cleaned. They'll send somebody, but I'll have to pay for middle of the week cleaning.
Well, we can
He's
address.
not going to change the sheets. He's not going to do any of that. I have to get somebody to do that.
Well, Cheryl, we could, we'll deal with those fees at trial.
Okay.
There is a midweek cleaning included. I'm not sure whether it's Tuesday or Wednesday, but it's one of the days.
Well, the other option, you can flip these schedules if that works better. If you're concerned, Ms. Kerber, that it's the sheets are not going to be thrown in the washing machine. The other option is you can flip the weeks.
No, thank you.
Do you want to do that?
No.
She's fine with the way it is, Your Honor. We can always address any fees later on in the case at trial if need be.
The court is simply urging each party to be considerate of the other. That's all. All right, so Mr. Danielska or Mr. Jones, either of you want to voir dire your respective clients regarding this recommendation?
No, Your Honor.
No, Your Honor.
All right, the court would urge the parties to continue their discussions toward resolution rather than just sitting on this case between now and December. There's a lot of time to explore. Maybe need more of a direct mediator like Attorney Godfrey if there are some complex issues need to be addressed.
Well, we would have hoped to have used him.
November, December.
We would have liked to have used him, but he represented my client in a personal injury case, Your Honor. So there's a conflict.
Mr. Godfrey is uncomfortable handling the mediation.
Well, he represented her. I don't think it was ever looked at because of those reasons, Your Honor. Because he had represented her previously.
Well, but it was a personal injury case. I'm just indicating, Mr. Danielski, I know for a fact Mr. Godfrey's mediated case where he knew both parties socially, but they both knew that Godfrey could call like he saw it. So just wherever it's worth, Godfrey can maybe more direct in terms of maybe more so than Mr. Pepper or Mr. Mena. I'll leave it to the parties, but unless you inquire of Mr. Godfrey, I don't think he'll don't assume he'll automatically refuse to attempt an effort to help these parties reach their own resolution. So just a suggestion. In any event, if there's nothing further, the court will adopt the recommendation. And now we'll conclude this hearing. We can all, we're going to zoom out. Have a good rest of the afternoon.
Thank
Thank
you.
you, Judge.
Thank you.
Welcome.
Cheryl's pissed.
Thank you, Ms. Brower.
Thank you, Miss Brower.
You're welcome, Your Honor.
You're welcome. You figured it out, Miss Brower. You split the time. Who'd have thunk it? Sorry, I shouldn't be mean. I don't know. Why am I in a bad mood? I don't know why I'm in a bad mood. But everybody's pissing me off right now. Probably because I'm coming to the end of my fasting or my non-fasting period of time. Anyways. The sharing of the time sharing. Guys, orange is not the new black when it comes to court. Don't wear orange to court.
Can I ask you a question, Stephanie?
No. No, Stephanie, no. Fucking Stephanie.
She's here.
Christina, she stepped out for just a second.
Okay, Aaron, can I ask you a question real quick?
Yes.
We are abating support today. There's an IWN, which has a large extra amount added in for the arrearage, which is essentially going away today. So I'm just trying to get an idea how long it might take for a new IWN to be created in light of the much reduced arrearage.
We could probably get that sent out today.
Awesome. Okay.
If your client has any information as far as an email or a fax number for payroll, we can get that sent over quicker that way.
Okay. Can you get that to me, Brian, and I can get it to them? So
yeah, I'll get you my office lady down in Toledo with fax number.
All right, sounds good.
Toledo
So at least we
office
can
will
get
send a
that
carrier
big extra
pigeon.
amount taken care of right away.
Thank you.
We'll send it by smoke signal and carrier pigeon. Also, Christina, do that before you get on to court. Don't waste everybody else's time with that shit. I bet you billed him double for that. Didn't you? That sounds good. I made soup today. It was pork, Napa cabbage, potato soup. Delicious in the Instant Pot. But the window is closing. And these people are sitting here looking like pumpkins, angry pumpkins. And I'm eating candy. No wonder I haven't got a zit. Oh, I just remind myself I already had dinner.
Calling the matter, Felicia Gamola versus Brian Stein.
For the record, this matter is before the court on the defendant's motion to vacate a child support to retroactivity provisions of a referee order of March 15th, 2024. This hearing is being conducted via Zoom. President Attorney Christina Hills representing the petitioner, Brian Stein. Mr. Stein is present. In addition, the plaintiff, Felicia Gamola, is also present. Good morning, everyone.
Morning, Your
Good
Honor.
morning.
The parties have conferred with Mr. Pratt from the front of the court this morning, who has provided the court with a fine recommendation that the child support shall be abated from April 1st, 2021 to February 20th, 2024. Father paying to mother. The father shall be given a credit of $1,816 that mother owed to father. Ms. Hills, is this recommendation agreeable with your client this morning?
It is, Your Honor. That solves our issues.
All right, Ms. Gamola, do you understand the issues that have been presented by Ms. Hills and addressed by the front of the court this morning?
Yes, that he doesn't want to pay the support from 2021.
To 2024, February 20th, 2024. That's correct. And that you also be given a credit of $1,816 on any, I guess, arrearages due to you. I'm sorry, the arrearages that you owed to Brian. Do you understand that?
I owe to him?
He'll be given a credit that mother owed to father.
Okay, I'm not understanding what that means.
Right? Should that be reworded, Ms. Hills, or?
Your Honor, at the time when the orders changed, there was an arrears owed by Ms. Gamola to Mr. Stein. So we're just, instead of having her pay him and him pay her, we're just giving him a credit for what was originally owed to him because of the way the order was written. So we're just abating the support that was ordered for that period. And then the money that was owed from Ms. Gamola, we're going to have put as a credit on Mr. Stein's arrears so that they're not paying each other. That's all we're trying to do.
All right, do you understand that, Ms. Gamola?
Yes. Yeah.
All
I
right,
get
thank you for the explanation, Ms. LaPrade.
Thank you, Your Honor.
And all right, anything further this morning then, Ms. Hills or Ms. Gamola?
No, Your Honor, I'm satisfied. Thank you.
Ms. Gamola, anything further?
No.
Okay,
No,
all right.
that's it.
All right, thank you for the explanation, Ms. LaPrade. The court will adopt the recommendation. That will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Thank you, Your Honor. You too.
Welcome.
Boom, 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 boom.
Right now.
All right, print time will continue as previously ordered. So meet at 5 o'clock at the Fridays and Sundays at the Flagler Police Department.
That's even more abrupt than the other one. Are you telling me they had to take 2 breaks? Are you telling me these people had to take 2 breaks? It's the same guy, right? Look. Watch what's going to happen. Yeah, it's the same guy. I think this one's first and then the next one. Abstract painting.
Recalling the matter of Michael Rodriguez versus Chelsea Rodriguez.
For the record, Ms. Rodriguez has personally re-entered the courtroom, having conferred out in the hallway by phone with her attorney, Stephen Rotenberg, who's present on the Zoom this morning, along with the plaintiff father, Michael Rodriguez. Mr. Rotenberg, you've had an opportunity to discuss fully discuss with Ms. Rodriguez these contempt proceedings.
Yeah, yes, Judge, I did, and she understands the seriousness of the situation.
And is she willing to admit to contempt?
Yes.
Right, to Mr. Rodriguez, raise your right hand to be sworn, please. Do you solemnly swear or affirm that the testimony about to give this matter will be the truth, the whole truth, nothing but the truth of God? Please state your name for the record.
Chelsea Rodriguez.
Ms. Rodriguez, do you admit and acknowledge that this court ordered you to personally appear with the children in this?
Remember, this is the case where she was sitting in the car and she got all pissed off about having to switch their schools because she registered them in Ohio or something. Ooh, follow up. Accidental follow up. It's almost like I do my job sometimes. Hi, Hector.
Courtroom on September 4th, 2014. And you admit and acknowledge you failed to do so.
Yes.
Why?
Well, first and foremost, I was thinking that day that the meeting place was Flat Rock.
You didn't show up there.
Before that, you were ordered to appear with the children at the Flat Rock Police Department. You did not do that, correct? Then the court ordered you to appear in this court, and you likewise failed to do that as well. Okay.
The day after is when I got the email, and then I realized it said to appear here.
This court in open court said verbally to do that, to appear at the Flat Rock Police Department, and to exchange with Dad. You didn't do that, correct? Is that yes?
Correct.
And then you also failed to comply with this court order. You didn't bring the children to this court on September 4th.
That's when I would have been meeting him the same time.
But you didn't.
And you have no valid reason for failing to comply with this court's order.
I did have an appointment set that day with my OBGYN at 2:50. So there was just multiple reasons. I also got a text from him that felt.
Who's him? Your OBGYN?
No, I'm sorry.
Attorney?
The kid's father.
Does he have a name?
Michael.
Okay.
I'm sorry. I got a text from him after court that felt threatening. It said, "See you at 3" with exclamation points. I
was excited to see my children. Yes.
Hold on, Mr. Rodriguez. Don't interrupt.
Sorry, sir.
It made me feel very uncomfortable. That doesn't give an excuse for me not going there. I really wasn't there because I had the appointment. That did not make me feel safer to come and meet him, because I did have somewhere to be. So after I got that text, I just felt really uncomfortable then. So I just kept with my appointment and I did not show up to give him the kids. I do apologize for that. I do understand that your orders are your orders and they do need to be followed.
Mr. Rodriguez, the court will not buy that. The meeting place was to be at a police department, Flat Rock Police Department. It will not buy the fact you felt uncomfortable when you're meeting at a police station. And yes, you could have rescheduled your OBGYN appointment. You didn't tell the court on that date you had an appointment and it was critical, could be rescheduled. So the court finds that you've flagrantly, intentionally violated this court's order. Court will only find you in contempt of court. The court orders you for 45 days in jail, but that's gonna be held over your head right now. So you hold the key to jail. So if you step over the line once violating this court's order, you're buying yourself some time in jail. Do you understand that? Up to 45 days.
I understand.
Okay, with that, the court previously ordered the children shall continue in Monroe Public Schools. They're not going to Canton schools. And you have a pending motion right now to change them to Canton schools. Court's going to deny that request because they've already started school. You should have filed that motion back in the summertime. you want to change them, file it next summer. But the children need consistency. So they will continue where they're at in Monroe Public Schools. The court will deny your motion. It's not set for hearing. I don't see a hearing date. And that was filed in pro per. Mr. Rolenberg, you represent Mr. Rodriguez on this, her motion to modify, to change the school district?
Yeah, but I don't know if I don't recall writing that motion.
No, she filed it in pro per. It's not set for hearing, but the court's going to deny that at this point in time. It's too
Okay,
late.
I was unaware that
School right now, it is mid-September. We're
Ms.
not going
Brower.
to yank them out of school, and we won't be able to have an evidentiary for at least 30 days.
Judge, Ms. Brower was trying to pipe in about something.
Your Honor, the friend of the court did schedule that hearing before referee Homrich on October 3rd at 10 a.m.
Okay, we're going to vacate that hearing date. This court has got in front of it, and the court's going to deny, read her motion, and we're not going to bounce these children around.
They were already they weren't at Monroe for long. He switched them at the end of last year. They had a whole school district for 3 years. They were in Dundee.
Okay.
So like Monroe Public Schools
The front of the court,
isn't there.
hold on, the referee recommended back on August 14th that children attend Monroe Public Schools. No one has filed any objection to that recommendation. It's going to order the court, and this court also ordered that on September 4th. So that issue has been addressed. If you want to change schools, you file a motion next summer. So with respect to parenting time, maybe perhaps parties should talk to Ms. Brower regarding parenting time. I know the prior parenting order says that during the summers, it should be week on, week off. During the school year, it's an alternate, mom has alternating weekends, Fridays at 5 to Sunday at 5. But does that interfere with your work schedule? Because there was concern about the children being left alone because of your work schedule. You now have a job with Ford Motor Company, is that correct? Okay. Ms. Brower, can you talk with the parties? I'll step off the bench. You can talk with parties regarding parenting time. I don't know what Mr. Rodriguez's position is, but I know there's concern about the children being left alone when Mr. Rodriguez was working. So it's just a matter of whether or not the parties agree to continue the parenting time that was ordered back September 4th, week on, week off during the summers. That's a no-brainer, but during the school year, the last order was mom has parenting time alternating weekends, Friday at 5 to Sunday at 5. I'll change it to the Florida Police Department. So yeah, maybe I just ask you, Mr. Rodriguez, are you still good with that schedule?
The only thing I ask is Fridays. She can pick them up from school at like 3:40 when they get off and make it easier for her, and she could have them a little sooner if that's the case. Because I go in at 3 o'clock unless she can meet my girlfriend to drop them off at the Flat Rock police station, and she doesn't have a problem here dropping my kids off with her here. So I don't know why that would be an issue. But I'm just saying she could easily pick them up from school. She's on the pickup list and everything. So I'm giving her the opportunity if she wants that. Trying to make it easier for both of us. And then Sunday it'd be at 3, right?
Right. She's talking here, so I'm having to
sorry
talk
about
with
that.
Ms. Brower regarding these issues. Obviously, we don't have a clear agreement this morning, so.
But we got the next little bit. That'll be the last part, by the way, for tonight. A short one again. I apologize. But we are indeed on the home stretch.
Right now.
What?
All right, parent time will continue as previously ordered. So meet at 5 o'clock at the Fridays and Sundays at the Florida Police Department.
All right.
Mr. Rodriguez doesn't want to agree to anything right now, so that the prior order will continue. Mr. Rolenberg, you have anything you want to add?
Not at this time, really, no.
Okay.
Yikes. I think he should have sent her to jail.
But it sounds like I have to file another motion, which I just did, like I was told to do.
Talk with Mr. Rolenberg. I mean, file another motion, what, to modify parenting time?
Chelsea, give me a call and we'll discuss it.
So
And as referred to front of the court, Ms. Scott conducted an investigation, formal investigation recommendation. You should have received a copy of her recommendation.
I never received a copy of the recommendation, nor was And I did call friend of the court about that, and that's what I did try to speak about last time. I called friend of the court because I knew there was an investigation from her after the 21 days. I never got a phone
It's
call. I
a,
never got anything in the mail.
We'll provide you with a copy of the letter. It's August 26th, in case you failed to cooperate with respect to the investigation. Copy was mailed of the report to Mr. Rotenberg. The children were, Layla and Kian were interviewed. Their opinions were taken into account. So if you want to, you come around to the window and we'll give you a copy of this August 26th recommendation.
I did ask her for a copy, but she would not give.
Okay, we'll give you a copy. It's in the court file. It's a public record, and then your attorney has a copy. So if you want to step out. So at this point in time, the court will simply enter an order finding Mr. Rodriguez to be in contempt, reserving the 45 days, holding that in abeyance, denying defendant mother's motion to change school district at this point in time, and continuing the parenting time order of September 4th, 2024. Mother shall have parenting time alternate weekends, Friday at 5, Sunday at 5, a meeting at the Flag Police Department. So when, I guess we need to agree, when will mom's parenting time begin? Will it be this weekend?
Yeah, this weekend.
All right, so
Wait, are you saying I only get?
that's correct.
How?
Okay, that's
I
the
can't hear
order of
what
this
she's-
court.
I can't, she has to speak more clearly in the microphone.
Given when I had them
Okay.
full time.
Okay.
So he got them during the week and 2 weeks and those weekends.
This was
now.
ordered.
The mother, I'm only given the mother. My oldest is not even his child. We did a step parent adoption.
That's
No, you had me
showing the
adopt her,
records issues.
Chelsea.
All right, we'll give you a copy. Step out. We'll give you a copy of the front of the court recommendation for information. You come everyone come out by the window. And so yeah, meet this Friday at 5 o'clock, the Flag Police Department, and then again on Sunday. Comply with this court order, please. All right, that will conclude this matter.
Your Honor, I'll have a recommendation in your queue in just a moment.
Thank you.
Who thinks we'll be seeing them again? I
Erin,
do.
Stephanie says you're taking the 10.
Yes, I'll take the 10 o'clock.
Okay.
Sir, can you make a copy of both of these to give to Mrs. Rodriguez, please?
Yes.
Please. Yep. Both those. Okay, Mr. Rodriguez, you can step out and go by the window and show those copies for you. Lock that door, please. She leaves. All right, that will conclude this hearing. We're going to zoom
Okay.
out.
Thank you, sir.
Welcome.
Welcome, Cindy. I don't know what else is happening in this. Oh, what? What? What do you got, ladies and gent?
Oh, yeah.
Oh, it's the orange people again. We already saw you folks. I already critiqued your outfits. They sucked. Spoiler alert, your outfits sucked. Don't wear orange to court. It's not a good look. You look like a criminal, even if you're not. Anyways, I hope that you guys had a wonderful evening. I certainly did. Wow, an hour. Just like that, gone by. Anyways, I hope that you'll join me again tomorrow. We're going to do another TPO tomorrow. It'll be an earlier show, but I appreciate each and every one of you for being here. If you're new here, hit that like button, subscribe, do me a favor. We're on a very slow march to 3,000 subscribers. Well, let's say we're marching to 2,500. Still slow. But you can join us and we'll have a blast of a time. Remember that I love you, I am proud of you, and I will see you in the next video. Bye.
Ways down red.